Hi, Attorney Steve Vonner. We're back. We are talking in this video about the real estate recovery account. Okay, the real estate recovery account, we have it in Arizona, we have it in California. We practice law in both states. If you've been a victim of real estate broker fraud, deceit, misrepresentation, conversion of trust funds, those kinds of things, and you sought and obtained a judgment, a criminal judgment, restitution order, an arbitration order, a civil judgment, a final civil judgment, you may be entitled to seek recovery of your funds from not only the bad doer, you got to go get them first, but if you can't recover, you have a potential to seek your funds from the California Real Estate Recovery Board. Let's talk more. Let's head to the Attorney Steve Litigation Whiteboard. Okay, so we were talking about the real estate recovery account. We have it up there. There it is. This, as we talked about, is a civil judgment, criminal restitution order, a arbitration award. This is known as the victim's fund. The victim's fund, okay? So if you've been wronged by a real estate licensee in a real estate transaction, in an act which required the real estate license, you may be entitled to reward. Let's take a look how this works. Now, first question I get from a lot of people is, where does that money come from? Does that come from the taxpayer? No, it doesn't. It comes from the licensees when you pay your renewal fees and brokers who have accusations who pay fees. If you're issued a cite and fine, what they call cite and fine up to $2,500, part of those monies go in and accumulate in this recovery account. So it actually starts accumulating into a pretty large sum of money that the state, the Department of Real Estate, Bureau of Real Estate, has to pay back to victims of real estate licensee fraud. So let's talk a little bit more about it. That's who pays. A lot of these claims get filed. According to some information on the BRE website, about 50% of these claims are paid out. So there is a good likelihood of recovery, 50-50. Not bad. But let's talk a little bit more about what you need, okay? Again, it has to be a transaction that relates to real estate. It has to be an act requiring a real estate license. So make sure you get that box checked. There needs to be a finding in your case in either the restitution order, the arbitration order, the final civil judgment. It needs to state, and it's important when you're getting these judgments, make sure it states our grounds. Fraud, okay, we all know what fraud is. Misrepresentation, deceit, intent to defraud, the intent and the scienter to defraud, or conversion of trust funds, okay, so where you have clients and brokers like property managers that maintain trust funds, conversion of those trust funds that results in a loss to an owner or beneficiary can be something that can be sought recovery of. So those are your grounds. We got that covered. You got your intentional fraud cover. Time frames. How long do you have to bring a case with the recovery account? Here's the important thing. You're going to have to act pretty quick. You don't want to sit on your rights. When you get that final judgment or that criminal restitution order, you have 1 year. 1 year. Okay? 1 year to bring that claim. If you're tardy, if you're beyond that 1 year, you blow it, okay? So you want to make sure, even if you don't have all your information, sometimes you're up against the deadline, make sure you get it filed because you'll get an extra 15 days to add additional materials if it's found that you have a deficiency. So don't worry about having everything. Try to get everything when you're filling out the forms, but if you're running up against the deadline, don't blow it. That's a short 1 year statute, okay? So make sure you hit that. Again, attempts to collect money on bankruptcy. One of the questions that they're going to ask you when this form is filled out is the judgment debtor, the guy or gal got hit with the fine or judgment, have they filed bankruptcy? If they filed bankruptcy and you didn't go in and pursue them in a bankruptcy court, remember that there are certain judgments that cannot be wiped out in bankruptcy, including debts that are incurred in bad faith or in fraud. So, but the BRE wants to know, did the judgment debtor file bankruptcy? And did you go into bankruptcy court in an adversary proceeding, let's say, and try to stop them and get a determination that this debt was non-dischargeable, or did you not? So these are things you're going to have to point out and certify to them. Let's talk about the form. You're filling out the form RE807B. RE807B, you can find it online, or Attorney Steve always providing you that cutting edge information. You can find out more at realestaterecoveryaccount.com. That's realestaterecoveryaccount.com. I've got these code sections and the requirements, things that you need to make sure you're satisfying. You have your BMP 10471C as in Charlie, BMP 10471C as in Charlie, and Reg 3102 requirements. And we've got those listed on our website. I'm not going to go into them here. Check us out, realestaterecoveryaccount.com. Some important things about your recovery account actions in California: generally not allowed to recover your attorney fees, generally only going to get your actual and direct losses attributable to this licensed activity, and you're not going to get any sort of punitive damage award. Okay, so don't be going in there thinking you're going to walk out with a $2 million reward. Okay, there are limits on what you can recover. Okay, so you want to make sure you fill out the forms right. We can fill out those forms for you. We make sure that there's some service that's involved. You need to make sure that the licensee is going to get put on notice of this action because they're going to get a chance to object. You want to make sure all your information's there that they're asking for. And we can take these cases, usually we can take these on a contingency fee basis. Give us a call to discuss. Now, when you fill out the final form, there's going to be a signed declaration under penalty of perjury where the person seeking the recovery is going to attest to the judgment, to the fact that this was not discharged in bankruptcy or it was pursued in bankruptcy and found to be non-dischargeable, and also that these acts required a real estate license. You're going to give a narrative explaining everything, and you're also going to say that there was no inadvertent parties left out, like you didn't sue somebody because you liked them and you only went after this person and not this person. So you're going to have to make this good faith declaration. Okay? Time frame. Oh, let's go to show me the money. Let's go to show me the money. Max you can recover $50K per transaction, $250,000 max payout per licensee. If you have multiple parties seeking a maximum payout above this amount, you can end up in a proration action filed by the Bureau, and it gets prorated amongst the different parties. So that's your basic rule of thumb for what you can recover. Time frames: you have 15 days. You submit your claims within 1 year. You have 15 days where the department, or the Bureau I should call them, has time to send you what's called a notice of deficiency. That means you've got more items you've got to submit, get the rest of these things to us. So you have those time frames. And then usually when you get everything in, you're going to have a decision within 90 days. So it's a pretty good time frame, not bad. It's not as bad as probably not as long as you waited to get your judgment in court. So, but you have 90 days for that recovery. Now, if they grant the recovery, the licensee is normally going to lose their real estate license. They're going to lose their real estate license, yes, you heard me, until they pay that back. So, you know, it's a pretty harsh remedy, but when licensees are out there causing damages, they don't have insurance coverage, they don't have personal assets to cover the damages. That's what this victim account is for, okay? And let's talk also about the judgment debtor. If the judgment debtor wants to object, this is again why it's important to have an attorney. If they object because they don't want to lose their license, you could get into the battle of the briefs, and that's where you want a good attorney advocating on your behalf, spelling out the loss, tying it into the transaction, and making your best case for a maximum recovery here. Now, if it's denied, the aggrieved party has 6 months to go in and seek a verified complaint in a superior court, and if the court orders on the opposite, if the court says that their judgment does issue and there's a licensing issue, the judgment debtor then can go seek a writ of mandate in superior court, and we can help brokers on those types of actions. So that's a basic overview of the BRE recovery account. There's, as I mentioned, a similar account in Arizona. If you need more information, check out our website, packed with information and the forms and the requirements. Yes, we have it all there for you. realestaterecoveryaccount.com. Okay, thanks for listening. This is Attorney Steve Vondran. You need some help in business and real estate law, litigation, we're here to help you. We'll see you soon. Have a great week.